For those of you who don't know me, my name's Amanda Stewart and I'm the Chief Executive of the Policing Board, and I'm delighted to welcome you here today to our offices to the 7th and final in this series that we've had relating to the policing plan. It's hard to believe that back in May 2017 we started this series, and we have looked at issues such as cybercrime, child sexual exploitation and hate crime. Today's seminar focuses on an issue that has come up in many of these discussions: the impact of crimes on victims, how policing works with the wider criminal justice system to achieve better outcomes, and how we can best rehabilitate offenders, prevent offending and reduce reoffending. So to share his perspectives, we are delighted today to be joined by Phil Bowen. Phil is the Director of the Centre for Justice Innovation. He has a wealth of experience in this role, having worked in the Home Office, the Ministry of Justice, and also as Crime Advisor in the Prime Minister's Delivery Unit. As usual, we'll have time for questions and answered, and I'm pleased that in addition to Phil, we will also be joined in the panel with our Board Vice Chair, Debbie Waters, PSNI's Assistant Chief Constable, Mark Hamilton, and our Criminal Justice Inspector, Brenda McGuigan. You're very welcome. We will, of course, be looking for questions from the floor, and I would ask you just to get your thinking caps on as you hear some of the inputs from today. The weather is atrocious. We have battered through this all winter, and we get to the last one, entering into spring, and we are in sub-zero temperatures outside, so we do plan to finish up today very sharp at 1:45. And I know that it's probably an issue that could go on much longer. Just in terms of practical arrangements before we start, we will not have a fire drill. I don't have my coat with me, so we're definitely not leaving. Please make your way out of the building if the alarm does go off, because it's not a drill, and follow our staff. Photography will be taken during the event. If you do not wish your photograph to be taken or to be used in any of our publications, if you could just indicate to one of our staff here today and let them know. As I mentioned earlier, we're also streaming this event today on our YouTube channel. If you're going to ask a question, I would ask you to take a microphone so that people here on the live stream can hear us. And you're also welcome to make any comments on Twitter using our hashtags, hashtag NIPB Live, hashtag Policing Matters, and tagging us at NI Policing Board. Thank you, and we will see a short film.
The central purpose of the criminal justice system is to deliver an efficient, effective and fair justice process for all in our community. But the system itself can be confusing and difficult to navigate, particularly for victims of crime who may not understand the individual roles and responsibilities of the agencies which play a part in delivering justice. As the police service are often the first point of contact for people who have been a victim of crime, how officers engage with them is crucial. It's important that victims understand the various stages of the criminal justice process, their rights, and what information and support they will receive. Police investigations for some crimes are becoming much more complex to progress. This can impact on the time frame for gathering and compiling evidence for the submission of police files to prosecutors, for a decision on who is to be prosecuted and for what offences. The time cases take from crime to court, if that's the recommended outcome, can often be subject to delays. Speeding up the criminal justice system has been a priority since devolution, as delays impact on the confidence of victims and witnesses, their families, and the whole community. Recent figures show that processing time for criminal cases dealt with in Crown and Magistrate courts in Northern Ireland have all increased. Strategic outcomes and measures set by the Policing Board seek improvements in the quality of files and disclosure arrangements between the PSNI and the PPS. The police are also asked to promote and achieve effective partnerships with the PPS and other key partners in the criminal justice system to deliver a professional service which strives for positive outcomes for victims. New initiatives and new technology in the delivery of justice is central to improving the system and the experience of all those who come in contact with it. Evidence on new approaches such as problem-solving courts can also help reduce offending and contribute to reducing crime overall. The draft programme for government commits to greater collaborative working, but is enough being done, and what more is needed? We'll now hear from Phil Bowen, Director of the Centre for Justice Innovation, who will share perspectives on how policing and the criminal justice system can deliver better and more positive outcomes.
Thank you very much. We've heard there just at the end of the film an introduction to the next session, which is Phil Bowen. If I could just introduce Phil. Phil has been the Director of the Centre of Justice Innovation since July 2012. Before joining the Centre, he spent the majority of his career in the civil service, having worked in the Home Office and the Ministry of Justice, and before becoming the Crime Advisor in the Prime Minister's Delivery Unit. Before that, he also spent secondment in the Centre for Court Innovation in New York City, and some of this is contained in the presentation, so a wealth of experience, and we're delighted to welcome him here today.
Well, thank you very much. Thanks to the Policing Board, to Amanda and Deborah, particularly thanks to Lorraine, who not only helped extended the invite to me, but also told me a lot about which trains to get from Derry to Belfast, which window to look out of, and all that kind of stuff. So I've had a good last couple of days. It's quite an honour to be the last speaker in this seminar series. As the last son in a family of 5, I've always thought that being last is reserved for the best. So I'm hoping in that spirit I can live up to that. So I've been asked to think about the justice system and how it can be better. So what I'm going to try and do is give a very kind of broad overview of things that I think are interesting and positive out there in justice systems across the international landscape, which will touch on some of the themes that have already been outlined. So it's going to be kind of broad rather than deep. When you ask your questions, if there are matters of detail, you might have to write to me and I'll pretend that I know what the answer is in the future. But I'm trying to give you a sense of what I think is creative and interesting out there. So yeah, from crime to court, can our criminal justice system deliver better outcomes? So as the video kind of said, obviously our criminal justice system has a number of purposes. It needs to be fair. We'll unpack what we mean by that in a bit. It needs to be swift, have some sense that it goes through things relatively quickly. It needs to be efficient. It needs to fit the overall profile of money that we have for the justice system. It needs to be effective. Again, what do we actually mean by effective? We'll unpack that a bit. Some people suggest it needs to be reparative towards victims, towards the communities that are affected by crime. And there is some sense, I certainly share this view, that it should be engaged and responsive to communities. There are certainly some politicians back in London who possibly don't sometimes get that, but that's a bit too political. I'll move on from that swiftly. Anyway, but should it be engaged and responsive to communities? So those are the kind of, as you can tell, that's a pretty big thing that we're asking the justice system to do, and some of those things are maybe not contradictory but need to be balanced against one another. So fairness, should our system be fair? Should it also strive to feel fair too? So what do I mean by that? We at the Centre feel that there's a kind of traditional view of fairness, which is the kind of traditional legal sense of due process, rules of evidence, disclosure. Now obviously that stuff is incredibly important. But what's increasingly interesting to us is this idea of procedural fairness, that if people feel that they've been treated fairly by an institution, they're more likely to obey its decisions. We think that has a number of consequences for police and for the criminal justice system. This is from a Ministry of Justice research report from 2011, I think, which said, fair and respectful handling of people, treating them with dignity, listening to what they have to say, all emerge as significant predictors of legitimacy of the justice system and therefore of people's willingness to comply with the law in the future. So how do you do that? How do you make your system feel fair as well as be fair? So, and again, I'm just going to kind of broad brush approach to some of the things that I think are interesting. So in New York State, they've been redesigning how they summon people to court. So still using the same process, but changing the language that they use around the court summons. So using behavioural science and procedural fairness, they have redesigned their court summons to tell people, for example, not just when to turn up at court, but when their case is likely to be heard, whether they'll have to wait or not, what the facilities are at the courtroom. Those things seem to have changed people's behaviour. It's reduced the number of failures to appear, there are fewer warrants for arrest and fewer remands in custody. So some small changes to how you talk to people, how you communicate to people seem to have an impact on outcomes. We at the Centre for Justice Innovation have been doing some work around young adults going to court. So we know from the research that young adults feel that the court process at the moment is not particularly fair for them in magistrates' courts in England and Wales. They don't understand what's happening. They often feel like they don't have a voice. They don't feel like they're treated with respect. So we have been working with 5 magistrate courts to look at how we can use service user-led design principles to rethink the information that goes to young adults before they go to court, what their courtroom experience is like, how do we redesign that courtroom experience within the limitations of the fabric of the estate and the people there, and how do we give them better post-court information. And in sort of later in March this year, we'll be publishing the research that we've been doing on that work, which if anyone wants to know more about that project, my colleague Claire, who's sat there in the third row, she's actually been doing the hard work. I'm the gloss. She's actually the one who does the hard work. So in that example, we're trying to see how can we make the process fairer for young adults. Again, from the States, looking at domestic violence, they were looking at the impact of better information for domestic violence litigants, i.e. the perpetrators, and found that those who were given an explanation of what the court orders were, had a chance to ask questions about how those court orders were going to be enforced, were more likely to comply with those court orders than those people who hadn't had that information session. So I think the evidence of procedural fairness and the way it's being applied shows that we can change subtly some small things about how we run our system, and that can lead to changes in outcomes. So that's fairness. Moving on to swiftness. So it's been a big issue in England and Wales. How do we get the system to be quicker? Is justice delayed also justice denied? Now that is not a new phenomenon, that's been around for a while, so just put a quote up here. 1,000 wearinesses and 1,000 delays have to be endured, so often we are prepared, benches are set out, but we have to adjourn. That's a quote from Juvenal, a Roman satirist in 127 AD, about the court process in Rome. So the issue of timeliness has always been with us. In England and Wales, there's been a lot of pressure to get cases through quicker, but it's pretty tricky. So there's been a big programme of work called Transforming Summary Justice, which is all about creating a swifter system with reduced delays and fewer hearings. However, the impact of that has been this. So if you look at this chart, this is how long court cases take. So number of days is up on the x-axis. Hasn't really changed. In fact, for serious cases, court delays have gone up. So there's been a lot of effort to make things quicker, to have fewer hearings, but court delays have gone up. Now, part of the reason is because we've closed quite a lot of courts, so we're trying to cram more business into fewer courts. That particularly has been a problem at Crown Court. So getting swiftness in the system is really hard. But there's a kind of different concept of swiftness that I wanted to talk about a bit briefly, which is the idea of swiftness once we've already sentenced people and in the enforcement of court orders. Because I think it's an interesting thing about how swiftness can help us reduce reoffending. So this is the ultimate criminal justice study tour, which is Hope Probation in Hawaii. If anyone ever gets to go, please see if I can come along with them. It just is clearly the best thing you could do. But anyway, so they run a program called Swift and Certain, which is about swift and certain court order enforcement. So offenders submit to regular but random drug tests. If they fail some of those tests, sanctions are delivered within days of a detected violation, and they provide certain short-term jail days as a sanction, sometimes as short as 3 days. And then they're brought back to the court, put back on the treatment. And they go through a number of, if people keep on violating, they get, I think, 3 or 4 goes at it. The research around this SWIFT court order enforcement programme shows that hope offenders were less likely to be arrested for new crimes, less likely to skip appointments with probation, less likely to have their probation revoked, and that model is spreading across the USA and Australia. So when we think about swiftness in a different way, we can see that it might have an impact on outcomes. Efficiency. So does limited public money and old court estates prompt the need for more technology in court cases? This is some work that we're currently doing quite a lot on, because as some of you may know, in England and Wales, we're likely to be adopting new types of technology across the court estate to make things quicker and more efficient. So, what do we see from practice across the world? So, increasingly, what we're seeing is court systems investing in technology, which means they can entirely resolve low-level criminal matters completely online. Never see you get a court summons, and it says log on to www.michigancourt.org. You go on there, you pay your fine, and that's it. You plead out guilty, you get a criminal conviction. You never see the inside of a courthouse. So in Michigan, this is just one example, 17 state courts is using this online dispute resolution service for traffic tickets and failure to pay outstanding warrants. Seems to be making a difference in terms of just getting the kind of low-level cases through the system quicker. And it's something that in England and Wales, they're about to pilot if they can get legislation through the House. And that's a whole other political issue that we won't get into right now. So there's this move across jurisdictions to look at how can we resolve court cases entirely online. As well as that, there's also the idea that do you actually physically need to come to court at all, even if you've got a court case? So how do we use more video technology and audio links for court cases? This is going beyond just using it for remand cases where people are in prison and beam in on a video link, but actually using it potentially for trials, potentially for quite serious things in Crown Court. There have been some recent surveys on this showing that that kind of Skype-style technology is increasingly being used across the States and in Europe. So both of those types of technology are increasingly being used by courts as a way of speeding the whole system up. Alongside that, there are some interesting pilots around things like how do we get automated real-time translation, particularly in jurisdictions with very diverse communities with different language problems. How do we move away from a model which requires physically someone to appear in court who's got language skills, but how do we use computer algorithms to do real-time translation? Things like speech-to-text technology, which could produce transcripts of court at a much reduced cost. So there's a whole gamut of work going on across jurisdictions around how do we use technology to make the system more efficient. But, and this is where some of our research is leading in the next few months, how fair is all of that? How real is that as a justice system? So, for example, in the case I was talking about before where people are resolving cases entirely online, those criminal cases are still criminal cases. They still have collateral consequences. So they still come with criminal records that can still affect people's immigration status. To what extent will an online system feel like it's a serious thing that people realise, oh, I'm actually pleading out to a crime here. That means that when I get a job in 2 years, that's going to appear on my criminal records check. So there's a whole question about, that might be fine for civil matters, but is this really something we want in our criminal justice system? And that's something that we're doing some exploration with the public about. Does this feel like the sort of justice system that you want? Does this feel right for a criminal justice system? Again, are video links fair? Are they real justice? So if having a criminal case entirely by video link, what does that mean for actually the quality of justice that we have? So we already know a bit from research that defendants who appear via video links sometimes feel like, well, this isn't really a serious thing because I'm just sat at home on a video link. That's different from having to be in the dock, for example. So there's some evidence that defenders don't perceive the consequences of criminal trials as serious if they're doing it by video link compared to when they're there in reality. appearing by video link can be difficult for various vulnerable groups. So people with autism equally have the sense that, well, they don't really understand that this is a serious thing. They don't fully understand that kind of stuff. Equally, obviously, video links for things like domestic violence domestic violence victims can be incredibly useful things. Again, we're exploring this issue. Does this feel less serious? Does this feel right for the public? Is this what our public should expect a criminal court to feel like? When essentially what they're saying in England and Wales is you could essentially open your laptop, appear at your criminal trial, and then, take your pyjamas off and go and do your day's work. Does that feel right? I don't know, that's a big question. Lawyers in England and Wales are also quite upset by some of this extension of video links because they think it impairs their relationship with their clients. So in a number of the pilots of this approach, lawyers are in the courtroom, their clients are elsewhere. How do you have a proper dialogue between your client when you're doing it all by video link? So these are big questions. Now, as an organisation that does research, this is always what we say, more research is needed. If anyone wants to pay us to do that research, I'm more than welcome. I've got business cards and all that kind of stuff. And also, one of the other issues around this kind of technology is, does it work? So often, I don't know what the experience is like in Northern Ireland, but we certainly know there are lots of magistrates and judges who really don't like video links in England and Wales because they keep on dropping out. They can never quite get the technology to work. It's almost like judges don't fully understand how to use technology, but I'll leave that to one side. So that's efficiency. Effectiveness, and this has actually been work that we've done for a number of years on how do you make the court process more effective. So traditionally, I think the view has been, certainly from court services, that the criminal justice process is simply to ensure fairness, and it's the job of probation and prisons to reduce reoffending. But are there opportunities to impact on outcomes earlier on? i.e., should we just leave it to probation and prisons to do that work? So firstly, are there more diversionary options for some offenders that are more effective, i.e., should we be taking some people to court at all? And secondly, can courts play a role in resolving offending behaviour? So one of the things we know from research is that taking some offenders to court increases crime. So in particular around young people, we know that roughly 9 out of every 10 kids arrested will age out of offending by around 17 or 18. Formally processing them through the justice system, either through out-of-court disposals or through prosecuting them, results in criminal records, labelling and other things that mean that they're likely to increases their likelihood of further offending. So how do we do maximum amounts of diversion? And again, my organisation has done a lot of work with youth offending teams and police forces in England and Wales to extend and deepen the amount of diversionary options that forces and yachts have for young people under the age of 18. So point of arrest diversion schemes that address low-level criminal behaviour without creating collateral consequences. We also know that kind of diversion option works particularly well for adult female offenders. So now there's very good evidence that placing low-level female offenders in gender-responsive and trauma-informed services is far more effective as a crime reduction strategy than prosecuting them. When we move on to courts, we also know from the evidence that courts that use ongoing judicial monitoring can reduce reoffending. Sometimes called problem-solving courts, sometimes called collaborative courts, sometimes called specialist courts, don't really care what they're called. They can actively involve the court itself in reducing reoffending. So the core components of that are specialising the court around a particular target group, some form of collaborative intervention and supervision, normally by a combination of probation, police and voluntary agencies, regular accountability hearings through at court with judges, this concept of legal leverage, which is the idea that if you're facing 3 years in prison and the alternative is 12 months of a drug treatment program, that's a pretty good carrot to keep you going through your program. Again, this concept of procedural fairness. So one of the interesting things that's come out of research from the States around problem-solving courts and why they work, not whether they work, but why they work, is there's something in the relationship between judges and offenders over time they see the same person, they form a relationship. It's almost like judges kind of become like probation officers helping someone through a process. I'm sure there are no judges in the room, are there? Judges get a bit nervous about becoming social workers, but that procedural fairness link really works. And it's a court that's actually focused on outcomes. How do we do things that change outcomes for the communities that we work in? So, problem-solving courts. What do we know from the evidence? We know that adult substance misuse courts reduce substance misuse and reoffending, particularly effective with high risk of reoffending offenders. And this morning we were actually talking to some of the court officials who are working on the substance misuse court that I think is going to be piloted in Belfast, all things going well and with a fair wind behind them. What else do we know from the evidence? Mental health courts reduce reoffending, but don't actually seem to improve offenders' mental health, which is kind of curious, but nonetheless that's what the evidence says. And then on domestic violence, we know that specialist and problem-solving DV courts provide a better experience of justice for victims. They feel that something serious and meaningful is happening to the perpetrators, and there's promising evidence that problem-solving domestic violence courts, that is ones that monitor people post-sentence, reduce the frequency and seriousness of perpetrator reoffending, which is obviously important in and of itself, but important from a kind of criminological background in that a lot of perpetrator programming on its own has kind of mixed evidence as to whether it works or not, but seems that if you yoke programs together with this judicial monitoring, it reduces frequency and seriousness of perpetrator reoffending. So, that's effectiveness in terms of diversion, in terms of problem solving. Again, because we're exploring the role of technology in the justice system, there are some interesting things happening around the application of new technologies to improve how effective court orders are. And we're getting into slightly Blade Runner type territory, so I'm going to pretend I understand all of this, but actually I don't. So there's a branch of artificial intelligence called machine learning, which is essentially computer algorithms that can look at vast amounts of data and learn new patterns and make better predictions. Recently, there's been research that's looked at judicial decision making in New York City and looked at what the judicial decisions are basically asked a machine learning algorithm, can you make a better decision than judges did? The answer was, again, if there are any judges in the room, I'm sorry, the answer was yes. So what they found when they ran the algorithm was that the algorithm could essentially produce these outcomes, that it could reduce the amount of crime caused by the population going through the courts without changing the rate of people going to jail, or it could reduce the amount of people on remand with no increase in crime rates. I.e., by making better decisions about who gets jail and who doesn't, we can either reduce our jail population or reduce our crime rate, just by making a better decision than we currently do. Now, certainly my organisation is not proposing that we replace judges with algorithms, but it's an interesting study. Moving on to kind of reparative, the reparative purpose of the justice system. So yeah, and I'm sort of preaching to the converted about the positive impact of RJ on reducing reoffending for offenders. We've been a big supporter of the use of our application of RJ, both in the adult system and in the youth system. The problem that we've certainly encountered in England and Wales has been this attrition rate with RJ. So this was a study done in 2014 about the application of RJ as a disposal from Crown Court pre-sentence. So the idea was someone who wants to be involved in an RJ conference would be referred by the court, they'd do their RJ, and that would then change the court disposition. And what we see is this huge attrition rate. So on the sort of leftmost column, it's all the victims available to the programme, the amount of victims contacted, the amount of victims that were interested in participating, the amount of victims and offenders interested, the amount of court adjournments, and the actual amount of conferences completed, and you see this real attrition rate. And we have seen that in other applications, certainly in England and Wales, of when we've tried to take RJ to scale in our justice system, which isn't saying RJ isn't worth doing, it's just saying making it a mainstream option has proved to be quite difficult, certainly in the court system in England and Wales. Moving back to the idea of how can we be more reparative and how can we use communication and procedural fairness to support victims. So one of the things we know is that just straightforward, simple information provision is useful for victims. So again, looking at some data from the USA, there's an automated program that operates, I think, in 3 or 4 states that provides victims with automated information about the offender's status changes, when they're going to court, that kind of stuff, and basically found that just better and more information makes victims happier and more satisfied with the justice process. Again, it's not rocket science, but certainly, again, in England and Wales, we don't do that on anything like as routine a basis as we should. And again, this idea of procedural fairness, i.e. the idea of the system feeling fairer, is as important for victims as it is for offenders. And in a Canadian study, it found that those victims who felt that they had been treated unfairly by the criminal justice system continued to experience more PTSD than those who felt they'd been treated fairly. So again, what we find from the evidence is some of these small behavioural science type things about the information you get and how you get your information really does make an impact on outcomes and people's sense of legitimacy. And then finally, to what extent should our criminal justice system be responsive to its communities? And again, I'm going to talk about some attempts to do that in a number of jurisdictions. So in New Zealand and Australia, as you probably know, they've got obviously big problems with the disproportionate amount of Maoris in their justice systems, in particular in their prisons. So they have been doing some work around developing culturally specific court processes and ADR processes for those communities, which show some promise. So it's a bit mixed as a bag, but there is some sign that it reduces reoffending, that it keeps those communities out of prison. It's pretty small scale stuff. They've also been actively trying to recruit community members into what is for them a new lay magistracy, i.e. the idea that volunteer members of communities should sit in some way in judgment over their communities. And I know there are some people in the audience who've been to some of the community courts in America from our sister organisation Red Hook in Brooklyn. Again, a great trip if you can wangle it. The idea of a community court, which is how do you have a locally based neighbourhood court which has a focus for services, can do housing court, can do civil court, can do family court, criminal court, all in one place with the same judge seeing all the same cases. And again, there's some interesting and positive evidence from those community courts. So the model itself is quite limited, and there's only about 30 or 40 community courts across the world. Part of the resistance to this idea of a criminal justice system being responsive to its communities, certainly in England and Wales, has been, does that affect the impartiality of the justice system? To what extent should cultural and community differences be accommodated? We've just had in England and Wales a big report done by David Lammy on black and minority ethnic disproportionality in the system. And there was, I know, a lot of concern about wanting to both have a system that was more culturally sensitive, but there are political risks around Muslim communities, Sharia law, all those kinds of things. So all of that stuff is politically difficult, but I kind of think you guys know that too. So concluding thoughts. So the sort of final thoughts that I have. So can our criminal justice system deliver faster, more positive outcomes? Simple answer is yes. I wouldn't be doing this job if I didn't think the answer was yes. I think the kind of things that I would hold up to be the kind of best bets, to put it that way. Firstly, this idea of procedural fairness. You don't have to do radically different things. You just need to talk about them in slightly different ways, and you can achieve better outcomes. So just to go back to the example I was talking about a bit earlier about young adults, the work we were doing with those 5 magistrate court areas were things like just spending an extra 2 minutes confirming the young adult knew what was going on in court, giving them a chance to ask questions, and not asking questions in a, did you understand this? But is there anything about this that you need further explanation about? And actually you find when you say, did you understand this? Most people go, yeah, of course I did, because you don't want to look like a moron. If you say, is there anything I can clarify? They go, well, actually, what does probation actually mean? So you don't actually understand what a community order is and all that kind of stuff. So there are some very simple things you can do. So I think a good bet is procedural fairness. I think some of the new technologies that are coming down the road do need to be adopted. So I am privately an advocate for resolving more criminal cases online, but I do think we need to test it out. I think we need to test it out with the public. I think we need to proceed with caution. I think it's actually a way that we could reduce the collateral consequences of the criminal justice system. I think we need to have a discussion, certainly in England and Wales, about if we're going to have this, what does that mean for our criminal record system? If you plead out online in 2 minutes, as you would buy something on Amazon, does it really make sense that that comes with the criminal record? So I think there's a whole debate to be had about that. Certainly effective crime reduction strategies like diversion and problem-solving courts require clarity about who should be offered these options, i.e. you don't want to up-tariff people just because you've got an attractive, great problem-solving court. You don't want to put people who otherwise would just get a fine into a 12-month community order. And finally, one of the things that we find just across all the work we do, and it's kind of the final note from me, the things that we've seen that work best, the things that we think have the most energy, the most innovation, the most creative, are those things where people actually ask service users, the victims and the practitioners how this can work better in practice. I have seen, certainly when I was in government, far too many things, which is some guys who think they're bright in a room in Whitehall come up with a plan and impose it on an area without actually thinking through, does this work for the police? What would a service user think about this if they were going through it? What do victims actually want? And we find again and again that the things that work best are those things that are sensitive to how service users see the world, how victims see the world, and how practitioners see the world. And using that in the design of your programs is your best bet. So that's it. That's it from me. Thank you.
Well, thanks very much. That was very informative. I'm just going to ask Brendan and Mark and Debbie just to join the panel. I'm conscious of time, and I have given a commitment to be out of here at 1:45. So rather than put a question at this stage to each of the panel members, maybe if I could turn to Debbie first. But what I would like to do is actually just ask the panel just to give a couple of minutes on their reflections on what they've heard, because there's quite a lot in that presentation. Debbie, we'll maybe start with you first.
Yeah, thanks, Amanda. As Vice Chair of the Board, it's really good to see everyone here today. Thank you for coming out on such a horrendous day, and hopefully we won't get snowed in. But on a light note, I think the main thing that I learned, Phil, from your presentation is that I need to go to Hawaii. Is there anyone else in the room that wants to visit the Hope Project in Hawaii? I think that would be a good starting point, but you and me, Mark. But I suppose with my policing hat on, obviously, the big issue that stood out for me was the need to engage with communities. Because I think what we have learned, probably sometimes in a very difficult way here, is if you don't have people at the centre of your processes, people that are impacted by those processes, whether that's people who offend or whether that's people who have been hurt and harmed. If you don't have processes that have them at the centre, and not necessarily led by them, but where they have a voice in the process, that's when we do business much better. And Phil, that was the big thing that stood out for me, because I think everything else flows from that. So as a policing board, to build confidence in policing, we need to talk to the people who are most impacted by policing. And often we know that's the people in our most socially disadvantaged and most vulnerable communities. I used to work in a program in the States, a restorative justice program just south of Chicago, which was called a last chance program for young people who offend. And the big thing that stood out for me was that most of the young people in that program were white, because young Hispanics, young Latinos and young African Americans didn't get a last chance. They were just incarcerated, and young white males were sent to the last chance program. So there's something in what Phil has said to me about engagement, but also how we are culturally sensitive to how we do business, and who are we serving by our criminal justice system, and how can we help that system be tailored to their needs, not in a way where they're running the process, but in a way that serves everybody well. So to reduce offending, we reduce the number of victims. And it's really important in our processes that we not only serve the needs of victims, and we do that quite well here, but that we also serve the needs of those people, both young and old, who offend.
Thank you, Debbie. Mark?
Thank you for the invitation. There was no round of applause today, and I actually wanted to applaud sort of vigorously. I found it fascinating. I really did.
We'll do that at the end.
And it's in a way quite refreshing. Having been involved in delay in the justice system here for many, many years, I suppose, and the attempts to reform it, there has been probably a very kind of granular attempt to fix bits of the system. And where we're concerned obviously to fix the police, and a lot of attempts to reduce delay in process change and in cultural change, none of which I think all of which I think are very, very important, and are part of a responsive police service that needs to be effective and efficient in what it delivers. But it was fascinating to listen to your commentary on the effectiveness of transforming summary justice. I know it was quite light touch, but that despite all the kind of front end cold-faced efforts, it's not reducing delay in the system, and I think that's something we should all listen to. To be honest, it resonates with what I felt in preparing to come today, because what you talked about to me was far more a systems and societal approach to how we view justice, delays in the justice system, the balance between the needs of offenders and those of victims, the balance of efficiency and effectiveness, and trying to get the right outcomes. And I think that's entirely the space where we need to be. I think in Northern Ireland we are slightly fettered by the very necessary changes to the criminal justice system that evolved out of the peace process, that very necessarily ring-fenced the notions of independence between each of the criminal justice partners. I think that's entirely necessary, and I wouldn't seek to dilute it. But the solutions to these are in a joined-up systemic change. The solutions, as I listen to yourself, is an end-to-end crime-to-court process. The solutions also feel to me, in listening to your presentation, lie in both more industry, harder work, driving out inefficiencies, but also in innovation and design and risk-taking across all the piece. I often feel, even though the police service are quite often blamed for their ineffectiveness, I often feel that we're very keen to be innovative. We often get engaged in innovative pilots, only for them to peter out, and for things not to gather traction throughout the whole of the justice system. And I felt from listening to you that, you know, the missing key for all of us is that desire to be risk-taking, balanced needs across the system, and to try things across the piece, and not to look at single things as an answer. So it's not going to be digitising the system is going to make it all better, but it might make a bit of it better. But it might make a bit of it better than if we had the courts adjusted in a certain way to manage that, the prosecutions viewed in a certain way. So all signed up to the concept of fair, swift, efficient, effective, reparative but also restorative. And I could speak very firmly for the police service in Northern Ireland that we are firmly nailed on to the notions and the prospects for restorative justice, and engaged and responsive. I mean, our policing with the community strategy at its heart is about engagement. Victims of crime and offenders are at the heart of our communities, and therefore those principles have to sit firmly inside our policy development and our responses. To be honest, I could go through every line of what you said. I was fascinated by it, but I suppose, Amanda, those are the sort of the key headlines that came out from me.
Okay, thank you, Mark. Brendan.
Well, firstly, Phil, thank you very much indeed. I equally enjoyed your presentation. I suppose I'm in a privileged position in the sense of that kind of overview of the functioning of the criminal justice system in Northern Ireland. And you can certainly see improvements on behalf of the way most of the criminal justice organisations treat victims, for instance. That approach has been gradual, but we've got there. I think the establishment of a victims' charter, etc., raises and enhances the status of victims. But it was a slow and tortuous journey, and there was a lot of resistance to it. And for me, that's probably the fundamental issue, is how do you break down that fundamental resistance to change? That when you engage in a criminal justice process, that somehow it must go through a variety of stages. So in the Northern Ireland context, for instance, we're criminalising fewer children now than we ever did before. Lowest numbers that I can remember in our juvenile justice centre. Lowest numbers of young male offenders in the secure college at Hydebank Wood. Relatively low numbers in our prisons. Certainly lower than what they have been over the last 4 or 5 years. Fewer cases going through our magistrates' court. About the same number going through our Crown courts, but actually absolutely no improvement in the time that it's taken to process these cases. And that is horrendous. And no matter what is said about it, there is almost a complacency, a resistance to actually contemplate doing things differently. I probably, like many others, held out hope that somehow we would create a burning platform in Northern Ireland that would actually encourage organisations to think differently. And the money that was stripped out of criminal justice in England and Wales certainly focused minds and encouraged people to think about doing things differently. And certainly to forget about some of the nonsense that filled our courts. And largely that did happen. And alternative ways of managing things, and some of your talks there, dealt with the future possibilities of digitisation and use of video and online dispute resolution services. Get real here. Northern Ireland, 1.8 million people. Come on. With more hearing centres than, I see David Ford there, despite his best efforts. We have more hearing centres. We have more judges available to resolve these issues. So it is, for me, the challenge around how we get the cases into the court process, and then how we get those dealt with expeditiously. Nobody has mentioned the arts pilot. I probably want to forget about it, but actually the arts pilot in some ways told me that we can do this. When we apply our minds, we can deal with cases and get them out of the way. The single biggest issue for victims is the length of time that it takes for the cases to be heard. The attrition rates on domestic and sexual violence are horrendous, and most of those, when you speak to victims, is because of the length of time that they've had to wait. What do we know is that in our Crown Court cases, the vast majority of defendants plead guilty. Well, were they as guilty when they were arrested as they are 2 to 3 years later when they're standing looking at the white of the eyes of the victim who, oh my God, she's serious or he's serious, they're turned up, I want to plead guilty. And there is something here that is, for me, needs to be radically changed. I probably would have hoped that there needs to be some political cover for it, but we need to do things differently, because everything is achievable in the Northern Ireland context, in my view. The scale of our and the size of our criminal justice system is one that we should be performing much better than what we are. Despite the fact that there is all of this opportunities around new technology, and I embrace that, and I'm saying, yeah, absolutely. But actually, even as it currently sits, when we're using the Dick and Dora stuff that we've been doing for the last 100 years, actually we could do this a lot quicker, because there's fewer cases coming through the process.
Okay, Brendan, thanks very much. I'm going to open to the floor for any questions for any of our panel. We've got a couple of questions here at the front. We have one from Sean and then another one from Linda.
Thank you, and thanks very much for the presentation, which was highly informative. It's more a comment than a question, if I may. It's some of the key frustrations in working class communities is the timeliness and the effectiveness of the policing response to issues of concern for those communities. And then when it kicks into the criminal justice system, the length of time it takes. And also the lack of information in terms of feedback to victims during that process. Like Debbie, I picked up on your comments regarding responsiveness to communities and community restorative justice, because I think the two are interlinked. Because we're talking about being responsive to, what's a mechanism for doing that? And I think restorative justice projects, especially those accredited ones, are the bridge between the community and the police and the criminal justice system. And I think they can perform that role very well in relation to it, because unless you've got that bridge, it's a good concept, but concepts are no use unless we can put them into practice. So I think that's one practical way of ensuring there is this communication, this engagement between the communities, especially within our own local context, where you've got the historical baggage around policing and the criminal justice system. And some of these communities, regarded as hard to reach communities in transition, etc. So we really need to put a focus on it, and we are, and this is all our roles, to develop levels of confidence in our new policing dispensation and the criminal justice system. Then this is vital, that engagement process. Without that, we're not going to be successful in driving those levels of confidence where they should be.
I'm actually going to take the opportunity to ask a question of Mark in relation to that, because I think it raises the issue around whether, in terms of not victims are well served within PSNI, Mark. And maybe just for a couple of minutes, if you could talk about that perspective.
Well, the statistics from the victim witness, care unit that we have, would point to an 87% satisfaction rate. The confidence levels in Northern Ireland point to the highest ever confidence levels. And we often point to these figures. What we always have in Northern Ireland, though, is a disparity between those figures and then the sentiments that are presented to us from the community. And so on the one hand, the figures are all pointing generally to more positive victim experiences, and I would argue that irrespective of some of the criticisms of the policing service, I think we are more effective and more engaged and more responsive to victims than we ever have been. And that is still inside the increasing demand, the extra 30,000 calls a year that we're doing, and the diminishing amount of resources that we have to respond to that. I do think we are a more engaged, more effective, victim-centred police service than we've ever been. But I won't dispute that at a community level, and I don't think it's exclusive to communities in Northern Ireland. I think at working class community levels across the United Kingdom, there continues to be the disengagement with the policing services, and the policing services are regarded as being the criminal justice service. We are the front line, the visible piece to that, and therefore it's understandable that the police service becomes the primary but not the sole focus for people's concerns about the justice system, their engagement in the justice system, the responsiveness of the justice system, and the effectiveness of it. So I could talk probably quite all here about our engagement strategies, but I think I want to concede that I want to support the fact that on the one hand, the evidence points to more success in victim services, but equally that does not necessarily translate as well as we would have it translate for communities on the ground experiencing the justice system today. I think we have to accept that.
Okay.
But that doesn't mean we haven't got more to do to try and improve that.
Appreciate that, Mark. Debbie, you wanted just to come in on that, and I think maybe even the perspective in terms of class communities, if you could comment on that.
just very quickly, whether it's right or not, or fair or not, Mark has said the police are seen as the front face of the criminal justice system. So Sean is right. Communities don't really care what part of the system is broken or how it's broken. What they want is for it to be fixed and for justice to be done better. And oftentimes the police get the blame for everything. Now sometimes, Mark, sometimes you do get it wrong. But sometimes, as Brendan has pointed out, there are failures within the court system, failures within the PPS, systemic and sustained failures that need a joined up and cohesive solution. But at a community level, that does not matter. And I know some policing and community partnerships, PCSPs, have done workshops and pieces of work where they've brought people together from crime to court. So they've had the police there, probation officers there, people from the court system, magistrates, right along the spectrum, and got them to talk about their story and their part they play in the journey. And I think that's something we need to do more of in communities. We need for the PPS to become more open and transparent, but in a way that doesn't compromise their independence. We need the court system to do the same, so that communities, and especially working class communities that are often at the front end of this, begin to understand what due process means, what procedural fairness means, and how the system as a whole can serve them and not just the police. So with my policing board hat on, I'm going to recognise that the police do a lot well, but they often get the brunt of a lot of what the frustration within communities. We do need to do everything better, Brendan, as you have said, and we definitely need other elements of the criminal justice system to be more open and more transparent to communities.
Okay, thanks, Debbie. Linda.
Sean and Debbie have actually covered
Have
most
they
of my
covered?
points, to be fair to them,
You get
which
another-
actually I think is a good thing, because it shows that we're all really on the one page in terms of this, that it boils down to communities. And that was one question I was actually going to ask you, Phil. Thank you very much for the presentation, it was excellent. In relation to, you talked about mainstreaming restorative justice, and that seemed to be a problem. It wasn't proven very successful. Do you think that's because it doesn't have the say in front of it? Community restorative justice, because where the community is not part of it, where it doesn't come from the community, and that can become more difficult whenever you try to mainstream anything. It's the same as the challenge we have all of the time with the PSNA and obviously with other organisations, in terms of that the community has to be at the heart of it, and that doesn't mean statutory agencies. That means the community, the people in the community need to be at the heart of it and part of it.
It's a good question. I think there are probably a number of answers to it. I think one of the things is cultural. Certainly in my travels, I certainly find here and in Scotland there is a political narrative, cultural narrative about looking after our own, seeing offenders as part of communities. Without wanting to be too critical of my country of my birth, there are communities in England that, frankly, it's them and us. It's offenders are these other alien things, we just want them locked up. I think that's why we've got a relatively harsh, we've got the highest imprisonment rates in Western Europe. So I think there's a cultural problem that we have, and I get a sense that there are different jurisdictions in the United Kingdom that are on different journeys, and actually part of the job, I think, of my organisation is to promote that maybe the English have things to learn from other parts of the UK. There are certain factions of English political life that are impervious to that, but again I won't get into that in detail. So I think there is a cultural problem. I think there is also there's actually with RJ as it were in the formal justice system, I think it has a natural place, but I think it's also got a natural limitation. There are just frankly some victims who don't want to meet the person who offended against them. That could be because they're scared of them. It could be because, you know what, it's a house burglary in London, it's part of the cost of living in London. I'm over it. I don't really want to be involved. So I think there's always going to be a natural limitation to the amount of RJ that can be used in the formal system. So I think those are kind of two things. I think thirdly, there is a, kind of picking up on Brendan's point, there is a natural conservative streak in parts of the justice system in England and Wales. And I actually don't mean that necessarily critically. I think there are judges, for example, who kind of question RJ and think, is this really proper justice? Is this really the sort of thing that we should be doing? Actually, in that RJ pilot I was talking about, there were judges who said, yeah, it's great that these people go through these restorative conferences. It's great that they found some kind of emotional closure. I'm still sentencing them to 3 years prison. I'm not going to not do what the sentencing guidelines say. And the whole point had been to divert people away from prison. And they went, well, I don't see why that makes any difference to the sentence I'll give in the end. So there are all sorts of things going on. So I think, I've always taken the view that RJ at a community level is fantastic. I think particularly for young people, it's great. I think it does have a natural limitation on it, especially in the adult system. But I think you're also right to say there are peculiar English things that have meant it's just not extended as much as it could have.
Mark, you wanted to come in on this?
Yeah, I think it does have limitations, but I think every element of the justice system has limitations. Therefore, you have to apply the right option at the right time. Having been involved with community restorative justice elements for a number of years now, I'm not going to speak for Debbie or any of the other practitioners, but there has been a continuing frustration about how long it is taking to try and use the word mainstream this as an approach, and its relative positioning inside the criminal justice system. And I think that's a question for the entirety of the justice system and the community in Northern Ireland to answer, not just for the police service. We have said, look, we're up for it. We think it's a very cost-effective and practically effective way of dealing with certain offences and certain victims, responsible for certain victims and for certain offenders. And it does put the community at the heart of that process, should do. But there is, I think, a cultural concern about it. Some people don't want to touch it. There are all sorts of concerns about how it evolves and what it means and how it actually fits into the notions of, and I'm talking procedural justice in terms of evidential gathering, rules of evidence and so forth, the procedures of justice as opposed to procedural justice. And I don't know that we have, well, we've all talked quite nicely at times about it. I don't think that there has been a concerted acceptance in Northern Ireland that this should be a function of the criminal justice system with its place, with its recognised limitations and with its place. And, without trying to be kind of parsimonious about it, but it is cheaper. It is cheaper and frees up space. But it also produces in many ways better outcomes for those for whom it is appropriate.
Okay, thanks, Mark. Chief Constable, you wanted to come in on this?
Thank you. Forgive me, I had to nip out for about 15 minutes there, so if this issue has been addressed...
You just missed Brendan, that was all.
Just say, well, it might actually be, because I know that this is a topic close to Brendan's heart as well, so if it has been addressed, I can just get a download from somebody later, but it's two things, really, just to get the benefit of Phil's view or experience on. There is a real risk when you start looking, particularly at delay, but even beyond that into the treatment of victims and witnesses and so on, and very often the two are married up in the same sort of issues. But that as all of us practitioners or parts of the criminal justice sector run for cover, it's easy to blame each other. And it's almost a natural defence mechanism. But there is... So therefore, I think that what we need is a system-wide discipline that is non-negotiable. And I've been saying this for about 7 years. I previously worked in Scotland. I saw it there. I looked at the time limits and the time scales within the court system there, even for the most serious cases. And when I arrived there at the start, they frightened me, thinking we're going to have lots of cases falling off here because this is not doable. It is doable when it's not negotiable and it's set in stone. So I think the introduction of statutory time scales or limits from, basically from charge to sentencing is a healthy thing that would be difficult, and there would be the odd cause célèbre that might fall along the way in the early days, but it feels to me like it would bring a discipline right across all the partners and agencies within the criminal justice system. The man sitting to my left was my Justice Minister for 6 years, so
He's got his hand up.
He might have a view on this as well. But it was really to get your point, because I know that there are, I've discussed this with the Lord Chief Justice, who thinks I've got an overly simplified view of it, and maybe I have. That's one point. The second point, and this sounds like me running for cover and blaming others now, and it might be, but it's just to get your thoughts on this. We get, and acknowledging Mark's point, who speaks on behalf of the organisation for this, we know we have work to do internally within the police. Notwithstanding that, the single biggest factor that I think could make a difference, apart from introduction of statutory time limits or scales, is firmer, more disciplined statutory judicial case management. So defence statements in this jurisdiction, particularly for more serious cases, are an absolute nonsense. They allow the defence, and I would say this as a cop, but they would allow the defence to go on fishing expeditions, what the issues that need tested and proven or disproven at a trial, we never know largely until the day. It also creates massive disclosure issues because everything becomes relevant. Therefore, you could have 60,000 text messages to work through because we don't have any parameters because of a lack of judicial case management. And it was really just to get your view on that. I mean, we might be holding on to those two things, or I might be holding on to them because you need something to hold on to, but from your experience and from the research, is there anything that would either challenge or validate my hypothesis?
I mean, on time limits point, I think they are a useful discipline, but they need to, if you're going to do it, there needs to be a consequence for not meeting them. So one of the things that always struck me as very different culturally was, when I worked in the States for a year and a half, the courts there regularly throw out cases that have gone beyond their limits and say, okay, the public have not proved their case, this man is in Rikers jail and I'm going to release him today because you haven't got your prosecution case together. I have not seen in an English courtroom a judge get irate about the prosecution not being ready. So you see a German and delay and the thousand wearinesses of the Roman satirist. So I think if you're going to do time limits, they need to have a consequence. And I put up that chart that showed that despite all the efforts, timeliness had not really improved that much. More to say, look, this is difficult. It's not to say that you shouldn't do it, but it's difficult. I think in terms of case management, I think that the big thing that people are holding on to in England and Wales is this idea of a common IT platform that everyone can share documentation on and all that kind of stuff. Now, again, no one's going to say that's a bad idea. It's inevitable, and if we don't do it in the next couple of years, someone's going to do it in 10 years. It's just an inevitable part of an information technology world. Now, when it comes to judicial case management, and again, I can only really speak from an English and Welsh perspective, we, I think, have a difficulty, and I don't know what it's like here, in that our court administrators are, certainly at a magistrate's level, not really responsive to judges. Judges don't manage the cases. It's all done on their behalf by the court administration. They don't really have the power to say, hang on, I want this listed earlier or whatever. That's always struck me as very weird. I think judges need to be accountable for the management of cases through their system. And I think it leads to a second question, which is even more difficult, and possibly more difficult in this jurisdiction than in England and Wales, which is, how do you hold the judiciary to account for that? Who holds the judiciary to account for that? In our system, it technically should be the Ministry of Justice, but it's kind of blurred because it's an independent branch. How you hold the judiciary to account for getting cases through the system, I think, is a big, vexed question. So if they're going to take on case management responsibility, how do you say, actually, Lord Chief, this isn't good enough? Are you going to say that to him? I guess I haven't seen a system in which that has been adequately resolved. But I think if you're putting judges, I personally prefer the idea of judges being in charge of and accountable for case management of the court system. They're not really at the moment in England and Wales because that's the job of the executive agency, the court service. I would like, but then my second question is, well, how do we then chivvy them along? So anyway,
Thank
I don't know
you.
if you have it.
Once again, I was probably reflecting on the progress that we've made in how we deal with victims and witnesses in Northern Ireland. And once again, over a period of time from 2005, we first looked at this. I'm just about to embark on our 5th inspection of the treatment of victims and witnesses in Northern Ireland. But what our recent inspection work tells us that actually for the significant progress that the criminal justice organisations have made in being more accountable and outlining exactly what victims should be expecting in terms of their treatment as they go through the process, there does appear to me to be a real problem once it gets inside the court. And I probably was trying to think of descriptors around this, and it is that sometimes there's a sense of elitism and arrogance when it gets inside the court. And in my view, that actually needs to be turned on its head to one of humility. Because actually we all exist to serve in the public sector. There's no divine right in terms of employment, etc. The taxpayer's paying for it all, every last bit of it. And they should, every area of it should be directly accountable in terms of its performance. And, so I absolutely agree. I probably, in my worst days, I'll sit and talk about the nuclear options, and I've seen those rejected out of hand in the Northern Ireland context. The resistance, reluctance to consider statutory case management, statutory time limits, because they don't want to be bound that way. And that, the courts operate and, and largely, I would say, we don't have any real travesties here, are those that are readily identified and are dealt with. So generally speaking, it is fair, it's balanced, it just takes far too long. And in taking far too long, it is not serving the system at all. It's not serving victims, and it's certainly not serving offenders. And if I look at the impact of that remand prisoners has on our prison population, it is considerable. We're almost 3 times the percentage of remand prisoners in Northern Ireland in comparison to England and Wales. And it is, well, that's just the way we do things here. And it is, we need to change this. This needs to change if we're going to have different outcomes and raise public confidence in a belief that the system operates in their best interests.
Can I just add a final note, which is something I forgot to say, but I think one of the ways that you can hold, or that we could potentially hold the judiciary and the court service to more account, is to publish data, to be more transparent. We should have data, I don't know what the data's like here, where we can say, actually Judge X takes, on average, longer than Judge Y to get their cases heard. Now, why shouldn't we be able to say that? Why shouldn't we be able to say that Judge X seems to send more people to remand than Judge Y? Now, we're not saying, therefore, Judge X is worse than Judge Y. We're just saying, well, why is there variation? I think that sense of data transparency, we're doing it. I can go online and find out, is the GP up the road better than the GP down the hill? I'm not saying I should then be able to choose which judge I get, but why don't I know?
I think, Phil, in this jurisdiction, the judiciary probably see themselves as certainly independent, and rightly so, of the rest of the criminal justice system, but even independent of each other. And I'm not sure that benchmarking would particularly concern them. I mean, you see on judicial case management, we had a really, I thought a really good practice direction issued by the Lord Chief Justice in around November 2011. And if the government, if the Department of Justice or Westminster, wherever that seat of power is going to lie in the future, if somebody was asked to draft a bill, I think it wouldn't be that far away from what the practice direction issue was that the Lord Chief Justice issued. But it had this lovely caveat on the end that, the judiciary is the judiciary and are not bound by this. So some judges, particularly in more complex cases, have applied it very well, and others would appear not to have given it the same regard couldn't put it any more strongly than that. But so we're sort of alive to these issues, but there's this thing about judicial independence that I think is a valuable thing in our system. But there is something about all of us being accountable as public servants for how we do our jobs and how much money we spend and how long it takes to do them and all of that.
I guess the point is, does independence mean no transparency? Why does independence should also have transparency?
Yeah.
I don't see any reason that it shouldn't.
I'm going to ask David Ford, because you've been waiting to come in. David, is this in relation to what we're talking about, or is that a separate question, or were you just giving an observation on it?
It's about 20 different observations, so I'll try to cut them down a bit. First of all, thank you, Phil, both for your past engagement from CJI to DOJ and for today. One point which wasn't mentioned, and you asked the Chief Constable if he could tell the LCJ what to do. Well, when the Criminal Justice Delivery Group met under the chairmanship of the Minister, with the Director of the Prosecution Service, the Chief Constable and the LCJ sitting around the one table, nobody could actually direct, but there was an encouragement to cooperation which I don't think had existed previously. Because 20 years ago there were good reasons in this society why organisations emphasised their independence. We now need to much more emphasise their interdependence that we've been doing if we're going to make the improvements which are possible. And for example, the arts pilot which Brendan mentioned was the LCJ's initiative. But only he can really direct judges, if anybody can. In terms of time limits, I did hear a nice story recently of a district judge who asked for an adjournment at 10:30 one morning, looked at his watch and said, what about 2 o'clock? But until judges will actually take that response to solicitors who haven't done their work, then we're going to continue to see massive delays. One interesting point on efficiency. I've seen evidence that when you take an expert witness from, for example, Forensic Science Agency, by video link into court, juries believe them less than if they're in the box. Now, as the Minister who used to have responsibility for forensic science, I wanted them doing their work except for the hour they were needed in the box, not spending all day hanging around the court. If their evidence isn't believed, that's one downside of technology which also comes up. In terms of some of the issues about efficiency, I think the Victims of Witness Care Unit, the work done by Youth Justice Agency around conferencing, specifically restorative practice, where I have entertained an English minister saying good work done in Northern Ireland, the work of the Inspire Women's Project, all show that we have got some movement in this society of dealing with making things more effective by targeting them appropriately. When I had the opportunity to visit courts in New York, the most interesting thing for me was not Red Hook sitting at the back of the room, but Manhattan sitting on the bench. Where I saw the notes the judge had from probation and social workers, I saw the line of questioning that she was taking to offenders. And there does seem to be a point, speaking as a social worker by profession, that a judge managing the cases on a monthly basis backs up the work the probation and social work do on a weekly basis to make things more effective. But the question is whether our judiciary are willing to engage in that. We've seen that kind of thing in the domestic violence court in Derry, but I don't know that Barney McElhone's got very many colleagues who are willing to do that kind of work. And that takes us back around where a number of points have been today already.
Thank you very much for that. I'm going to ask each of our panel maybe just to give a few comments in relation to that, and also just some closing comments, because I'm very conscious of time. Brendan, do you want to go first?
Yeah, given George is here, but I think we're very lucky in Northern Ireland actually, and I've probably thought this for the last couple of years, that we do have very good leadership within the criminal justice organisations. I think what has been missing has been, and certainly over the last 18 months, is this drive, the political cover to enable things to really take off here. And I'm talking about transformational change. Having worked in policing and looked at it from the outside, it has transformed from the organisation that I belong to. When I look at the Public Prosecution Service from its early beginnings to where it is now, much more accountable and open. More to go, absolutely. No issues around that. Our court service, our youth justice agency, our prison service, now responding in a way, but there are no political drivers in Northern Ireland now, and I think we're much the poorer for it. And to enable that continued transformational change, I just worry that if you're leaving it down to the Criminal Justice Board, I would just worry that independence and the independence of each organisation will get in the way.
Okay, thanks, Brendan.
Phil? I agree with a lot of what you've just said, Brendan, and I think having the political cover to take risks is kind of key to innovation. I think one of the things we struggle with in England and Wales is often that political cover only comes from central Whitehall, though increasingly we're seeing with mayors and police and crime commissioners pockets of innovation across the country where people can just stick their neck out and go, what would it be like if we did X? I think you are very lucky in this jurisdiction. I was saying to someone earlier, I've been coming here since 2000, and I've seen just in society, culture, and in the criminal justice system, just this sea change. One of the reasons that I'm here this last couple of days is to go, come on English, look at how creative and dynamic things are here. Look how creative and dynamic there are things in Scotland. You don't have to go to Hawaii. You can go to Aberdeen.
Seriously.
And just kind of picking up what Mark said, I think it's right. To innovate, you need to take risks. And often what we need, I think one of the difficulties when we talk around innovation is sometimes you're not talking about the one big thing that's going to make the transformational difference. You're talking about what the chair of my trustee board calls 1,000 sanities, the small little things that just make a difference to people's lives. And I think I've seen that happen here, I've seen it happen in England and Wales, and I just think what that takes is people with a bit of humility, a bit of humanity, and the willingness just to take that extra step.
Thank you, Phil. Debbie?
I would just echo a lot of what has already been said, and I suppose in terms of where we're at currently, politically, we don't even currently in this jurisdiction have formal accountability of policing. We don't have the ability to make changes in legislation around statutory time limits. So we haven't the currency at the minute to be able to do the business that we need to do to innovate. So I think we need to accept that we need an assembly up and running. We need that as soon as possible. That doesn't mean we can't innovate in its absence, but does mean it's very difficult to innovate in a sustained and in a joined up way with all departments working together in its absence. And I think that's what we need. But just to name the fact that good work is taking place, there's some really good measures in the policing plan around policing and around how they work with victims. People here have taken risks on restorative justice. The police, probation, the housing executive and others have taken risks when there hasn't been the political will or cover to do that. We've had a minister in the past who's in this room who has really taken risks around community initiatives and around restorative justice. We have the ability to do this. And I said earlier that in a small jurisdiction and with the legacy that we have and the innovations that we've already done, if we don't seize the opportunities and grasp the nettle, I think within the next 5 years, then we have lost a really great opportunity to do business differently. It's within our grasp and we're doing some of it. We're just not doing it in the joined up, systemic, sustained way that we need to. And we as a policing board will continue to encourage the police to be part of that innovation and to be part of doing joined up work.
Thank you, Debbie. Mark, last word.
One of the main outcomes of accountability is that things get done, and there's no point in holding just singular parts of the justice system to account if you want an end-to-end justice system that works for everybody. And we found that in policing. I accept your point about the absence of formal accountability over the last period, but the accountability mechanism in policing have ensured to a larger degree that which is committed to gets done, and if it isn't done, then you have to explain for it, and that works. However, I think the last word I'd like to say is just, and it's back to the innovation point. In my organisation, there are lots of police officers and police staff who are innovating constantly and who want to try and do things to make things better. I think their frustration is whenever they actually bump into the structures of the systems and the demands of the systems. And really good stuff gets stifled. I hate using cliches, but we have more pilots than Air Lingus, all that stuff. With more stuff being tried and not continued, and so there's no lack of innovation with our people. There's no lack of desire to do this, and that's at the practitioner level. That's at the community level. That's at the cops on the street. That's at the people in the case progression teams and the sergeants and the inspectors, the police staff who push stuff along. And I'm pretty sure that's the same in the PPS and in the court service and in elements of the judiciary. But what we haven't got